Welcome back to the Friday Five for May 3rd, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Let's look at 5 quick questions in about 5 minutes, things that came up in different consultations and meetings this week that maybe you've had questions about before as well. Question number 1 this week, should I be an LLC or an S-Corporation? Now, this question is an oldie but a goodie. I get this question quite frequently, and the confusion is over whether an S-Corporation is a type of company. And so in this particular case, the caller is looking at setting up a company and wanted to create an LLC, but then had seen some information on the internet about S-Corporations as well, and was wondering whether the LLC or the S-Corporation makes more sense. And so the distinguishing factor between the two is, of course, that an S-Corporation is a tax election. It's not a type of company. It's a misnomer under the tax law that we call it an S-Corporation when it's really a tax election, but many people think it's one or the other. In this case, the individual is creating a single-member LLC, and when you create a single-member LLC, it often makes sense for you to do the S-Corp election. And that's why you'll see a lot of content out there about S-Corp elections and LLCs. And so especially in a single-member LLC, what you'll want to do is talk to your accountant and see whether or not it makes sense for you to make that S-Corp election. And this will usually be based upon the amount of income you will be receiving from the LLC. Question 2 this week, am I personally liable for a contract that was signed by an LLC? Now, this was an interesting case because the client didn't actually sign the contract when it was originally given to the business. In fact, the client was buying another LLC and was taking on the contract for future performance. Now, the problem is the client had looked at the contract that was signed by a prior owner of the LLC and didn't really want it to be going forward with the new LLC once he owned it. And so the question was, if I buy that LLC, does that contract come along with it? And the first way to figure out this answer is, are you buying the assets of the LLC? Are you buying the assets and the liabilities, which in this case, the contract would be a liability? Are you buying the entire LLC, or are you just buying a portion of it? So this is where it's very important that you understand what's in your documents and you know what you are buying and what you are not buying when you take over a business. In this case, the contract flowed only to the LLC. There was no personal guarantee on it, so the individual who's buying the LLC would not be personally liable. However, the LLC, if he continued to do business as that LLC, would be on the hook for that debt. Question 3 this week, what happens if my partner and I can't agree on anything in an LLC? This is becoming more and more frequent this spring. I've had a variety of calls and new clients where they have partners in an LLC, and things have just gone south for whatever reason. They're not getting along. And the question is, what do we do next? How do we resolve these disputes? Now, the common thread through most of these is that the LLC did not have an operating agreement. And this creates a problem because your operating agreement will actually have a mechanism for how you resolve these disputes. But if you've never signed an operating agreement, and in the case of a few of these different clients, they even had proposed operating agreements that were just never signed. So without that, you have to default to the laws of the state where the LLC is incorporated. And if you can't agree on things and it gets really bad, you may have to file a lawsuit called a dissolution lawsuit to resolve the impasses in your business. And as you can imagine, that can be expensive, it can be time consuming, and it can create a lot of hard feelings between the members of an LLC. So it's another good reason to remember, if you're setting up your LLC, especially with business partners, we want to make sure that the operating agreement is drafted and signed. Question 4 this week, can I have more than one attorney in fact on my power of attorney? This is a pretty common question where you have a parent who has multiple children. So let's say they have 2 or 3 children and they're getting a little bit older and they want to have a power of attorney in place in case somebody needs to manage their finances. And the question is, does it have to be just one child or can it be multiple children? And there's 2 ways to approach this. The first way is you can have one child appointed with the other children as successors, meaning if the first child is unable to act, you could have a successor attorney in fact step in. The other way you can create this is to have them be joint attorneys in fact. And if you do this method, you just need to make sure that your power of attorney says whether or not each attorney in fact can operate on their own or whether they all have to agree together before they take any major actions. Question 5 this week, if I move to another state, do I have to update my will and trust? So the simple answer to this is not necessarily. If you move to a new state, one thing you want to check on is any powers of attorney or healthcare directives or healthcare powers of attorney, because the new state probably has a state form that your doctors and medical providers are used to looking at, and they would prefer you use that form versus an out-of-state form. However, it does not mean that your prior document is no longer valid. It's just really a convenience, and there may be things in that state form in your new state that weren't in the old state that you'd like to make sure are included. When it comes to your will and your trust, moving to a new state does not automatically invalidate your prior will or trust. In fact, your will should be able to be probated in any of the 50 states and sometimes even overseas, so that if you have a will and you move to a new state, you don't automatically have to make an update, but you may want to consider it and meet with an attorney to find out if there are other will provisions in the state where you're in that would make sense to add. So, for example, informal probate is available in some states but not others. So if you were to move from a state that did not have informal probate to a state that did, it may make sense to amend your will through what we call a codicil to add an informal probate provision. Same principle with the trust. Normally your trust will be fine in whatever state you're in. It can go state to state. It's a living document. You can add assets to it while you're alive, but you don't necessarily have to update it just because you move to a new state. But again, I will always defer to the professionals in your local jurisdiction. So when you move somewhere new, speak to an attorney, show them the documents you have, and find out if new documents are needed. So that's it. Those are our 5 questions for the week. If you like this video, you can hit the like or thumbs up button below. You can head on over to YouTube or ayerslaw.tv.com and subscribe for future episodes. There'll be a link below where you can submit a question for future episodes. You can always go to andrewmayers.com. There's a red button on the front page. We can set up a legal strategy session to discuss your legal questions and get you some answers. Wherever you are, I hope you have a wonderful weekend.